Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is a legal journey into the past to look at one of the most significant Cold War government litigations against labor leader Harry Bridges. The whole story spans a 20-year period with 4 separate lawsuits brought by the government, a staggering legal drama involving immigration deportation trials, criminal prosecutions, and a civil trial, all brought by the government in a relentless bid to prove him a Communist Party member and thus deportable. His trials went to the U.S. Supreme Court twice, each time the Supreme Court reversed. Yet even then, the government continued filing new actions against him, successive more punitive than the prior ones. How did this happen, and how did the legal system become weaponized by the government? These are questions that today we are discussing in our current legal environment as people argue about the weaponization of the legal system. This topic is the subject of my book, titled Burning Bridges: America's 20-Year Crusade to Deport Labor Leader Harry Bridges. It explores the entire set of trials after going through the thousands and many, many thousands, indeed pages, of the 4 trials over a 20-year period he was put through, the FBI records I received from Freedom of Information Act requests, and other documents from prosecutors' files and from state and federal archives. This program will let us take a look at one of his 4 trials, specifically the second trial, hence this is part 1, where the legal system was in fact weaponized against someone as held by the U.S. Supreme Court, and we can help define the contours of what it means to be weaponized, the hallmarks of such a failed process, and the implications for due process in terms of these holdings and potential significance today, in terms of what kind of process courts demand. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law. Areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land, in our famed Yellowstone, that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail if you are so inclined, and let's get going in our exploration of how legal systems can be weaponized and how a lawsuit can turn into an example of persecution by prosecution. The lasting line from the Supreme Court on the Harry Bridges trials is this. Quote, "The record in this case will stand forever as a monument to man's intolerance of man. Seldom, if ever, in the history of this nation has there been such a concentrated and relentless crusade to deport an individual because he dared to exercise the freedom that belongs to him as a human being, and that is guaranteed to him by the Constitution." End quote. This was penned in 1945. Yet even then, the trials continued for another decade, with another trip to the Supreme Court and even more aggressive governmental trials against him. It raises the legal question, then, of persecution by prosecution, and how different legal rules can be used and applied to convert what is a case into a campaign. With all the talk today, and in recent years about politicized prosecutions, it gives us a useful set of historical cases to explore the legal issues. So here is what we will explore in terms of legal topics as we dissect one of the Harry Bridges trials. As an agenda of the legal education topics we explore through this CLE, we have the following issues we will explore. First, the enactment of laws and the significance of which branch of government controls the legal system at issue. These raise questions of bills of attainder. Second, we will explore the nature of the immigration agency system, including the selection of the judge, the use of evidence, hearsay in particular, which gives us a good quick review on that. Third, how due process as envisioned by our federal courts attaches to agency behavior and use of evidence in life and liberty deportation trials. Fourth, we will explore the lessons from this in terms of what it means to be weaponized versus what it means to pursue a case in good faith, an often fuzzy line that we as constituents of the legal system inhabit and must tread. And we will look also here at the treatment that befalls lawyers who often represent accused in these situations. Harry Bridges' lawyers found out what it means to upset J. Edgar Hoover and the FBI. This gives us an important chance to assess lawyering in contentious cases and the importance of our profession to diligently working for our clients within the bounds of the law and advocacy principles. We need to start by getting our bearings on the background facts, and you need the general fact background to Harry Bridges and his first trial, so we may delve into weaponized legal systems. Harry Bridges was a longshoreman in San Francisco who came from Australia when he was 18 years old. He spent many years working as a longshoreman in brutal conditions in the San Francisco port. By the time of the Great Depression, there was immense social and economic angst, obviously, and longshoremen started protesting against the brutal labor and wage conditions they worked under. As the labor unions tried to strike deals with management, Harry Bridges, simply a working man, started himself saying that the deals were not fair and were sellout deals between management and labor to enrich management and not really make the working conditions of the longshoremen better. The more he spoke, the more people rallied around his message and voice. He eventually rose as a result of this out of the working class into a near political union leader as he called for better management labor structure. The existing labor leaders rejected him, but the people were behind him. The result of this was a massive vote that was held to determine the future of the longshoremen in San Francisco. And his voice ultimately prevailed, provoking the breakdown in the inside deal between labor and management. He ultimately then called for a general strike, which occurred in 1934, and it was the first one on the West Coast in history. It literally shut down the shipping trade that the longshoremen were critical for. The photographs from this time period are amazing because it shows the streets of San Francisco completely shut down, much like our streets looked during the COVID pandemic for a while. You can see them in my book even. He now had a position of power because the people supported him. But the existing labor and management structures that wanted to control the situation did not simply back down. They pushed for the support of the local police to go and break the strike, which led to what is known as Bloody Thursday, an infamous event where police killed several protesting longshoremen as they tried to break the strike. Some were shot in the back as they were fleeing the police. The police efforts, however, did not work, and ultimately a deal was brokered. The result of the deal was that Harry Bridges and his vision came out as the winner. He was now in charge of the union, and it struck a deal that was favorable to labor. He had in essence broken the old structure. As soon as he rose to prominence, however, the management and labor positions that opposed him decried him as a member of the Communist Party in an attempt to get the benefit of the then existing immigration laws, which made it a deportable offense to be a Communist Party member. Remember, he had arrived at age 18, was here in what was then a lawful immigration state, but he had not received his citizenship. Therefore, if he was a member of the Communist Party under then existing law, he could be deported. A massive conflux of people from private interests to state and federal prosecutors and immigration officials started working together in what is a legitimate conspiracy to find evidence to prove that he was a Communist Party member. They spent massive resources to build a case. The drama of it is in the book, and it boggles the mind. Fake Communist Party membership cards were procured. People on death row were offered a pardon if they would finger him as attending party meetings. They forwarded it to the Immigration and Naturalization Service, specifically the Secretary of Labor Frances Perkins, the first female cabinet member in history. She and the people in Washington looked at the evidence and realized that it did not really pass muster, and so originally declined to take a case against him. But this public-private partnership continued and eventually put enough pressure on Secretary Perkins by forcing an impeachment proceeding against her that she ultimately relented and allowed a prosecution against Harry Bridges to occur for being a member of the Communist Party. This then led in 1939 to his first of 4 trials over 20 years, which is detailed at length in my book, of course, but is not the subject of today. You just need to know this for background. Secretary Perkins appointed the dean of the Harvard Law School to be the administrative law judge. He was on the short list to go to the Supreme Court, a deeply respected lawyer and dean of Harvard. Over many months and thousands of pages of transcripts, all of which I have read from the National Archives, itself an incredible legal archaeological exploration, he reviewed the evidence and rejected the government's case. The government's main witnesses were perjurers, even lawyers who had run with Al Capone and been convicted with Al Capone. And the case had no legal basis, and so he ultimately denied it in late 1939. At that point in time after now, almost 6 years of constant pursuit, Harry Bridges thought, well, I have won and they cannot deport me, so end of story, and I will continue running the union and doing what I do. But he was not so lucky. And this is what led to ultimately a second immigration proceeding that eventually went to the United States Supreme Court, which is the subject today of our Persecution by Prosecution program in terms of looking at how a legal system can become weaponized to achieve ends even after a first attempt to achieve an end fails. So as 1940 rolled around, Harry Bridges had no idea what forces his victory had unleashed. This brings us to our first legal issue we will look at, a bill of attainder, and how legal changes to address one problem may unleash others. Let's discuss the law and what happened after Bridges' victory. Congress was alarmed, and a bill was enacted which proposed bill stated, quote, notwithstanding any other provision of law, the Attorney General be and is hereby authorized and directed to take into custody forthwith and deport forthwith to Australia, the country of which he is a citizen. Harry Renton Bridges, whose presence in this country the Congress deems hurtful. On the floor of the Congress as the bill was debated, Bridges was decried as being un-American. For example, one congressman said, quote, he has not comported himself in the manner that has met with the approval of American citizens generally, end quote. That was Representative William Colmer from Mississippi. As the debate raged on the floor with different elected officials becoming more and more aggressive, one congressman proposed they add an amendment to the bill to eliminate any right of habeas corpus for Harry Bridges so that he would have no basis to go to the judicial branch for help fighting this bill. Bridges himself said that the bill was unconstitutional and asked to have the opportunity to come speak to Congress, but he was denied a hearing. One House member, the head of the House Un-American Activities Commission, Representative Dyes, argued sarcastically that the bill was constitutional because deporting Harry Bridges would impose no punishment on him at all, since he does not, quote, believe in our form of government. In view of this attitude, it should be favored to Mr. Bridges to get him out of the country that he does not like, end quote. Another congressman even proposed sending him off to the British Commonwealth to join the front lines and fight the Nazis. And then Congressman Ford from California argued that the bill overall was designed to make America safe for Americans, which yielded applause from the House floor. One congressman opposed to the bill tried to read a letter written by Harry Bridges into the record, but the majority objected to the letter being read into the record. After much fighting, it was eventually read into the record. But it was all for naught, as the House voted overwhelmingly to adopt this bill, 330 votes to 42 against. Let's start by asking the question, what is a bill of attainder under the Constitution? A bill of attainder is a law that directs the punishment of a specific person. The Constitution prohibits bill of attainders because they provide trial by legislature instead of trial within the judicial branch. For the Constitution's framers, therefore, precluding bills of attainder served a separation of powers purpose by safeguarding against politically driven legislative excesses. Here is the language from Article 1, Section 9, Clause 3. No bill of attainder or ex post facto law shall be passed. The Supreme Court addressed these provisions in the Reconstruction era, where it confronted a post-Civil War amendment to the Constitution of Missouri, which required certain people engaged in particular professions to swear an oath that they had never been disloyal to the United States. The Supreme Court held that the law's effect was to punish a group of individuals who had been disloyal, and the punishment they faced was exclusion from a profession. As a result, the Supreme Court held the law an unconstitutional bill of attainder. That is the case of Ex parte Garland. In 1946, 6 years after these events confronting Harry Bridges, the United States Supreme Court addressed an appropriations bill that cut off the pay of certain particularly named federal employees who were deemed to be subversives. This was an unlawful bill of attainder because it lacked the safeguards of a judicial trial, and since it also barred them from government service, it constituted a punishment. Today, courts have a three-part test used to analyze if a law functions as a bill of attainder. Number 1, if the law inflicts punishment. Number 2, if the law targets specific named or identifiable individuals or groups. And number 3, those individuals or groups would otherwise have judicial protections. But that is from the cases of United States v. Lovett in 1946 and Nixon v. Administrator of General Services, reported at 433 U.S. 425 in 1976. So we must now return to how the law looked in 1940, when this seeming bill of attainder was passed to deport Harry Bridges and deny him a judicial branch habeas right. This required looking exactly at the trial and the Bridges case, which focused on the question, under the then existing immigration law, of whether Bridges had been a Communist Party member in the 1938 timeframe, which was the charge. He, of course, won that case. And so Congress decided to amend the immigration laws to permit a deportation of a person if they had ever at any time in their life been a member of or affiliated with the Communist Party. That law would not be a bill of attainder and would not be vetoed by the president, but it would allow institution of new immigration proceedings. At the time of this compromise, Attorney General Jackson promised senators that in a new trial he would appoint a judge, quote, of real judicial stature and experience, end quote. As a result, this new bill in June 1940 passed the House 382 votes to 4 votes, named the Smith Act, which for those of you who have done immigration law will understand that the Smith Act of 1940 is an archetypal piece of immigration legislation that has been amended over the years, but still stands as a foundational piece of immigration law. Representative Smith, who championed and for whom the bill was named, stated at the time of the Smith Act of 1940's enactment, quote, "It is my joy to announce that this bill changes the law so that the Department of Justice should have little trouble in deporting Harry Bridges." You can find that in the Congressional Record at 86 Congressional Record 9031 from June 22, 1940. It was then signed into law on June 28, 1940. The other massive significant change to immigration law that came out of the first Harry Bridges trial was that now the Immigration and Naturalization Service was moved from the Department of Labor to the Department of Justice, such that the Department of Justice, working with the FBI, could manage all investigations and aspects of the immigration process. So now the immigration laws had been amended in 2 ways to survive constitutional scrutiny, and in August of 1940, the Attorney General ordered J. Edgar Hoover to investigate Harry Bridges. This was for the purpose of instituting a new deportation proceeding. J. Edgar Hoover personally traveled to San Francisco to oversee the launch of the investigation. After months of investigation, in late 1940, the FBI delivered its report to the Attorney General concluding that Bridges is a communist. And so the Department of Justice in 1941 issued an arrest warrant for Harry Bridges, with a trial set for March 1941, 6 weeks later. This brings us to the next phase of our legal odyssey into weaponized legal systems, the actual trial. As a recap for where we are, we have the Bill of Attainder, which led to the compromise of the Smith Act, the reorganization of the Immigration and Naturalization Service, and the Attorney General's ability to pick a new administrative law judge. The one other aspect to this which is particularly unique is the fact that the FBI was also focused on investigating Harry Bridges' lawyers. You see here a copy of a letter sent within the FBI, which I received in a Freedom of Information Act request, where J. Edgar Hoover is asking Connolly of the FBI to look into potential files that Bridges may have that prove his Communist Party membership, which are being held by the lawyers for security. But that is not all, because the FBI also sent a letter internally where J. Edgar Hoover told Connolly that in the event of a national emergency, Harry Bridges' lawyer should be arrested and placed in custodial detention. The lawyers, of course, at the time had no idea any of this was happening, but they were now also, because they had represented Harry Bridges in the first trial and other communists across the country in other communist deportation trials, themselves squarely in the crosshairs. So a new trial was set, and this time the Secretary of Labor would not appoint a judge, the Department of Justice would. The judge appointed was a retired New York State judge, Charles Sears. Because the trial was scheduled for 6 weeks out, Bridges' lawyers asked Judge Sears for an extension. He denied the request, finding 6 weeks ample time to prepare a defense. One of Bridges' lawyers was a single mother, and because she could not find child care for her teenager back in New York where she lived, she simply withdrew her son from school and brought him to California for the months of trial that were to occur. The trial then began on March 31, 1941, in a federal building in San Francisco, where the FBI and uniformed immigration border agents blanketed the building. The trial was dramatic, with myriad witnesses making astounding claims and cross-examinations with Perry Mason moments. One witness was James O'Neill, because he became the fundamental witness that Judge Sears rested his ultimate decision on. Let's discuss his testimony. He came from the broadcasting and newspaper industry and claimed that he appeared at a board meeting for the Maritime Federation Executive Board, who was voting to pick a new editor for its newspaper, where he typed up his resume on the spot and then got handed the job. He became successful working there and testified that the Communist Party became angry at him because he developed too much influence over Harry Bridges, and so he himself, a former Communist Party member, withdrew from the Communist Party. The prosecutor called him and put him on the witness stand. But his testimony started with his denial that he had any knowledge of Harry Bridges being a Communist Party member, and he claimed that he had never told the government that he knew Harry Bridges to be a Communist Party member. The prosecutor was angry and shocked at his star witness derailing out of the gate, and alleged through his questions of the witness that the witness O'Neill had in multiple prior interviews with the FBI stated that he in fact knew Harry Bridges was a communist member because he had walked into Harry's Bridges office and saw Harry Bridges pasting his stickers into his little communist membership party book in 1937. These are stickers that people would put in the books to show they paid their dues. But O'Neill now denied making such an allegation in his interviews. As it turned out, all these interviews the FBI did with O'Neill, where he allegedly made these statements, were never recorded in an affidavit for him to sign. Without an affidavit to impeach him then, the prosecutor called other government employees who had been present at those meetings to the witness stand, including one of the trial lawyers in the very trial at issue, as well as the stenographer. They testified that O'Neill had said in those interviews that he saw Harry Bridges pasting stickers into his Communist Party membership book. They also stated that O'Neill had claimed to be the only living person on the planet with visual evidence of the fact that Harry Bridges was a secret Communist Party member. This was done in an effort to rehabilitate their witness gone wild. It appeared that O'Neill probably had made those statements. After all, multiple government witnesses testified to it, so Harry Bridges' lawyers cross-examined O'Neill with caution. They focused on the underlying claim itself and the near-absurd megalomaniac nature of it. The idea that Harry Bridges, who was in 1937 subject to INS investigations for a pending deportation and running now a powerful labor union, but was secretly a member of the Communist Party and sat in his office openly pasting stickers into a membership book, they alleged, bordered on the absurd. One facing banishment for membership would not openly put stickers in a sticker book to prove he paid his dues. In short, they tried to make the argument that O'Neill was a nobody who wanted to become an important person in the day's events and made it all up, a story that seemed over the top. The question of how the merits of the story would be seen, though, is one in the eye of the beholder. There were myriad other witnesses, and you can read all the drama in my book, but for way of background, you should know that Harry Bridges testified in this trial as he did in his first trial. The testimony was contentious because the government prosecutor continually tried to argue that he was a member of the Communist Party and took orders from the Communist Party, and Bridges denied the orders, even at one point telling the prosecutor, quote, "You're just a fool," in response to one of the questions. In all, the trial was 10 weeks and spans thousands and thousands of pages of transcripts. 3 months later, Judge Sears issued his verdict. He spent the first 80 pages of his opinion establishing the Communist Party was a menace to America. When he then turned to the question of whether Harry Bridges was a Communist Party member, he rejected many of the government's witnesses as actually having perjured themselves and lacking credibility. But he did his decision fundamentally on O'Neill's alleged statements to the government lawyers, which under penalty of perjury O'Neill had denied making at trial. In short, Judge Sears believed O'Neill was in fact a perjurer at the trial, but nonetheless believed O'Neill's alleged unsworn, hearsay prior statements as being factually true as substantive evidence. That is, the government lawyers' and stenographers' testimony about what O'Neill once said allegedly, which he at trial denied saying, was taken as the evidence to hang the case on. As a result, Harry Bridges was ordered deported, and so this gave him an appeal to the Board of Immigration Appeals within the immigration agency. The Board of Immigration appointed 5 immigration judges to analyze the record and review Judge Sears' decision. In turn, it wrote its own 99-page opinion in January 1942, where all 5 members of the Board of Immigration Appeals unanimously agreed that there was no evidence to support Judge Sears' conclusions. As a result, they reversed the deportation order, at that point in time saving Harry Bridges. For our purposes here of the legal analysis of O'Neill's testimony, the Board of Immigration Appeals concluded that while it was probably true that O'Neill made such statements about witnessing Harry Bridges putting stickers in his membership book, there was no basis to conclude that O'Neill's testimony was in fact reliable, since he was an admitted perjurer already given his testimony at trial was inconsistent with that claim. He was a facial megalomaniac, trying to make himself a central character to the massive social and legal events at hand, when in reality he was a small-time editor of a pretty meaningless paper and was never a confidant of labor leader Harry Bridges. They also credited Harry Bridges' testimony and simply did not believe that he was sitting around in his office with his feet up on the desk, putting stickers in a membership book when he was fighting for his life. In short, it was too fantastical a claim to credit. Ultimately, they said that O'Neill played Ananias as well as Judas. Now, Ananias was a biblical reference to the disciple Ananias who was sent by Jesus to restore sight to someone, as O'Neill believed that he was the one person that could restore sight to America and save it by proving Bridges was a communist. Let's now pause and discuss again this concept of the weaponization of the legal system. At this point in time, in 1941, Harry Bridges had been under constant scrutiny and investigation by the Immigration and Naturalization Service and the FBI. He had been put on trial for months in the first case and won. And now the second trial, he had prevailed before the Board of Immigration Appeals, when all 5 judges agreed that the deportation proceeding was fundamentally flawed and that there was no basis to conclude that he was a member of the Communist Party. At this point in time, by all accounts, he certainly could assume the matter was at last resolved. But he was not so lucky. By now, the Attorney General, Robert Jackson, who had started the process, has been placed on the Supreme Court, and the new Attorney General was Francis Biddle. The Attorney General in May 1942 suddenly stepped in and reversed the Board of Immigration Appeals decision and reinstated Judge Sears' deportation ruling. Remarkably, there is not even evidence to show that the government lawyers actually filed a motion to do this, which could be done in very narrow factual circumstances to challenge the finding of the Board of Immigration Appeals. Instead, the record shows that the Attorney General simply did it himself. This, of course, is a massive event taken by an executive official that appears more political than legal and raises fair weaponization questions, since the typical process to even reach such a result did not occur. And as we will see, it impacted subsequent federal court judges and how they saw these events. Doubly odd in the Attorney General's decision, while he reinstated Judge Sears' deportation order, he overruled Judge Sears as to witnesses Judge Sears had concluded lacked credibility and found them to be credible in the campaign against Harry Bridges. Accordingly, when Attorney General Biddle reinstated the deportation decision in 1942, Harry Bridges was now literally at the end of the line within the executive branch. His only hope for any help would be the judicial branch. So now Harry Bridges went to the federal courts to try to get relief. This brings us to our next module as we assess weaponized systems, and it requires us to look at legal doctrines that define the relations between the branches of government. He filed a habeas petition in the Northern District of California in a case titled Ex parte Bridges, reported at 49 Federal Supplement 292 from the Northern District of California in 1943. It was before Judge Welsh. Harry Bridges made multiple arguments, including due process arguments, double jeopardy arguments, and arguments that the Board of Immigration Appeals' ultimate conclusions should be respected. Judge Welsh reviewed the record and concluded that the Attorney General's ultimate conclusions, after reversing the Board of Immigration Appeals, were legitimate. He concluded that even though Harry Bridges won the first trial, that was related, of course, to the different legal question of his membership in 1938, as opposed to his membership at any prior time. He also rejected the argument that the Smith Act was, in essence, a bill of attainder, given that entire history that you have seen, concluding that whatever the law was originally in the first bill, the law enacted was not a bill of attainder. He refused to look at the motivations of the legislators in enacting the law. As to the core question on the merits, however, of how to manage O'Neill's testimony and the testimony of the other witnesses, he ultimately concluded that the power over deportation belongs to the executive branch in the first instance and not the judicial branch. He discussed the fact that, quote, the opinion of the board carefully weighed and analyzed the evidence bearing on the issue of Harry Bridges' alleged membership and affiliation with the organizations involved, and the conflict on these factual issues were resolved in his favor, end quote. But then the Attorney General rendered his opinion where he instead adopted the findings and conclusions of Judge Sears. He then concluded that, given doctrines of deference in terms of how one looks at the record of factual findings, he would affirm the Attorney General. Harry Bridges argued in his habeas petition that the act of the Attorney General, and its undoing the order of the 5 Board of Immigration Appeal judges, was itself unconstitutional and denied due process because Harry Bridges never had an opportunity to even argue his case to the Attorney General. But the federal district judge rejected that, because he concluded that any further argument would have been unnecessary, given the fact that everything had already been litigated at length before the trial court and the Board of Immigration Appeals. His lasting quote is as follows, quote, the failure to afford petitioner the opportunity of re-arguing his side of the case before the Attorney General did not deny him due process, period, end quote. But how did he handle O'Neill's testimony? He ultimately credited Judge Sears' analysis, which had been adopted by the Attorney General, in terms of crediting the alleged interview testimony over the trial testimony, and ignored the fact that O'Neill had perjured himself at trial within that narrative. He also, however, concluded that if the whole case hinged on only O'Neill, he would find a lack of evidence because O'Neill was simply lacking in appropriate evidence. Remarkably, the district judge concluded that the statements of O'Neill were pure hearsay, and any fair opportunity to cross-examine him was entirely lacking, because he denied having made those statements attributed to him. He thus concluded that a fair hearing would not have occurred if the case had turned only on O'Neill, but he concluded other evidence supported the decision. Specifically, he concluded that the witnesses that Judge Sears had rejected as lacking credibility and being untruthful were reversed by the Attorney General, even though they had been affirmed by the Board of Immigration Appeals, and the Attorney General's decision had to stand. As a result, he concluded that the hearing was ultimately fair, and given the standard of review and deference, there was substantial evidence to support the order of deportation. Accordingly, the habeas petition was denied, and Harry Bridges was ordered remanded into custody. At this point in time, Harry Bridges had a last chance to appeal to the Ninth Circuit and potentially the Supreme Court. So he took his appeal to the Ninth Circuit, and let's look at how the Ninth Circuit viewed the record. After briefing before the Ninth Circuit Court of Appeals, the case was heard by 5 judges. The case resulted in a split decision in favor of affirming the District Court and the Attorney General and the deportation of Harry Bridges. It was a 3-2 decision. Let's take a look at what the majority held, and then we will look at what the dissent concluded. The majority noted that ultimately the trial court judge, that is Judge Sears, had the witnesses before him and was better able to judge their credibility than everyone else who subsequently looked at the record. This is at page 937 of the opinion. Given this, they ultimately concluded that given the standard of review and deference to the executive, the conclusion had to be affirmed. However, one of the judges in the majority wrote a concurrence where he noted that there is no doubt that the evidence here failed any clear, unequivocal, and convincing standard of review. But nonetheless, since this required more deference under the mere scintilla of evidence standard, he would affirm the Attorney General. Nevertheless, he specifically said as follows, quote, "In no case have I given the evidence more careful attention than in this one. However, such attention has not left in my mind the pleasurable satisfaction that, barring a very slight possibility of error, the truth has been revealed." Such satisfaction is beside the point here. The simple question this court must answer is there some evidence to sustain the charges? There is. So then we can see that even one of the 3 judges in the majority did not really feel that the truth was ultimately revealed by the underlying trial. Nonetheless, he joined 2 of his fellow judges to make the 3-judge majority, given the systemic standards of review and concepts of deference. The dissent was written by Judge Healy, who wrote a lengthy and impassioned dissent for himself and one other judge. He was particularly upset at the use of O'Neill's recanted and contradictory hearsay statements, and completely rejected the idea that the disconnect in O'Neill's testimony could be bridged by legal doctrines of deference. He said, quote, "No amount of philosophizing can serve to make a silk purse out of this obvious sow's ear." He further said that after reviewing the entire record, that it was patent to quote any candid person who takes the trouble to examine the record that the government had failed to prove its case. He then said, quote, "I desire particularly to point out what seems to me to be the fact, namely, that the crucial finding in this case was arrived at in reliance upon incompetent evidence. Evidence moreover received and considered in violation of a regulation of the department designed to ensure fair hearings and to safeguard the rights of aliens." End quote. He then looked at the full context of the Harry Bridges deportation trial from the original bill of attainder that existed and framed the case through that due process prism. He said, quote, "Rather than deport the alien on evidence which would be condemned and prescribed without hesitation by any American court, it would seem a more forthright procedure to do what was proposed in the first place: deport him by legislative resolution, notwithstanding the provisions of any other law." End quote. So we can see a complete collision between the majority and dissent in terms of the value and propriety of using O'Neill's contradictory hearsay evidence, which he had recanted at trial within the broader context of the propriety of the action. For the judges who looked at the case through the prism of due process, it was obvious there was a due process violation. But for the judges who looked at it in a technical manner through the prism of standards of review and deference to original fact finders, they concluded they needed to affirm the deportation, even though one of them said he did not think the truth had probably been discerned on this record. Let's pause and recap our issue of what it means to weaponize a legal system and how that plays out within the 4 corners of a courtroom, be it trial or appellate. These 2 approaches between the majority and dissent define the fault lines of judicial branch management of agency trials and serve to illustrate our issues of a weaponized legal system where an obviously very political set of issues find its way into litigation. Judges of good faith can clearly disagree on how best to manage it, precisely because these are such difficult cases. The first issue is that of deference to the original court. Embedded in that are two distinct questions. One, the issue of deference to the executive branch of government by the co-equal third branch of government, since the executive is primarily responsible for immigration. That prism affects how subsequent federal courts look at the decisions in terms of not reviewing them anew, and instead giving wide berth to the government in its immigration deportation process. The second aspect to the concept of deference applied in that case, but also applies in all of our cases, even when appellate courts review the federal district courts and their factual findings. Specifically, the idea that if a trial judge in the first instance is the one sitting in the trenches of a courtroom, watching the witness testify, seeing them shift in the witness stand, the way they may move their head, and the light, that person is best able to discern whether someone is telling the truth or lying. The level of deference given within that will define how a case can come out, such that even if the three appellate judges reviewing a decision may have themselves in the first instance never come to that conclusion, they will often affirm a contrary conclusion if there is some basis in the record to conclude that it was not completely unreasonable for the first judge to do that. That is exactly what we saw here in the collision between the majority and the dissent. The second issue is the nature of how the judges look at the totality of the litigation. Do they look at it through the full context of how this case came to be and what is really going on, as the dissent did here, which therefore saw a weaponized legal system that originally had started with a bill of attainder and instead created a new trial that was one that ultimately, the dissent said, really no different to a bill of attainder bypassing basic judicial standards? With a broad lens like that, jurists see the context of the case in a very different light. However, the majority in this case took a narrower lens and did not look at those issues, instead looking at the four corners of the trial record as simply a case to be reviewed based upon the facts and the law of that case. Where a judge stands on that spectrum for a given case, especially a case that has large political overtones, is critical to assess whether they will see it as a weaponized legal system, or simply a case that, even where the majority judge said he did not feel the satisfaction that truth had been revealed, simply that being a legal case that had a result that had to be affirmed. And that is ultimately the third point which wraps up all of these points, and that is what is the nature of due process in terms of highly politicized prosecutions. Is it about reaching the right result ultimately in terms of the totality of the situation? Or is it about reaching a result that could ultimately be justified even if seemingly wrong or seemingly thin in basis for the prosecution to begin with? Of course, in our modern day, with lots of people discussing pending cases and claiming they are persecution by prosecution, some of these issues we have discussed here cast a shadow over how you look at it, and how judges who take up these cases, especially higher appellate court judges, may ultimately see the legal issues. This brings us back to Harry Bridges, who at this point in time was facing deportation. As it stood by September of 1944, 2 federal courts and 6 federal judges had looked at his case. 4 of the 6 federal judges had concluded that he should be deported. Within the executive, 7 members had looked at the case. 5 had found he should not be deported, and 2 had found he should. So at this point of the 13 legal minds that had assessed the question, it was split 7-6 in Harry Bridges' favor. But of course, it is not a total vote count, and as it stood, he lost by a margin of 1 in the last case, and so was facing deportation, such that his last chance was before the Supreme Court. Let's see what the Supreme Court now did. Over a 2-day oral argument in April 1945, the Supreme Court battled with all the lawyers to figure out how to manage the case. One of the justices, Justice Jackson, had to recuse himself because he had been the Attorney General that originally initiated, as you recall, the deportation proceeding, appointing Judge Sears at the inception. So it was an 8-justice court for Harry Bridges. Before I get to the actual decision, it is fascinating to see how the justices discussed and perceived the case after the oral argument. We are able to do this because we have access to the contemporaneous notes taken by the justices during deliberations after oral argument. It is incredibly fascinating, and I will give you a couple of snippets. There is much more, which is in the book, but this is particularly interesting for purposes of our analysis of persecution by prosecution. In the Supreme Court debates behind closed doors, Justice Stone took the position that there's no limit in the right of Congress to expel anyone, and so it didn't really matter whether the issue was about a fair trial, so much as whether it hinged on there being any evidence to justify the decision, and if there was, then there is no need to look any further. Justice Black took the opposite position and asked, quote, suppose it said a member of the Democratic or Republican Party, end quote. That is, could they be ordered deported, like the Communist Party meme-ebers, showing that Justice Black at least saw this in broader due process terms about legislating deportations on ideological grounds. One of the most interesting comments is a comment from Justice Frankfurter, who was an immigrant himself. He said, quote, I have a special appreciation having come in as an alien. I speak from a depth of conviction about this country and its future. I consider the action of the Attorney General amiss and foolish. But he also then went on to say that if the court was to reverse and save Harry Bridges, he could envision a world where Congress would react even more harshly with more restrictive immigration laws, doing a great injustice to the future, because members of Congress will say, we will let no one in. These are particularly fascinating insights that let us understand the mindset of how judges look at litigations and whether they categorize them as weaponized cases, and how even when, for example, Justice Frankfurter can see it as what he perceives a weaponized case, how the court should respond to it and deal with it for fear of future reactions by other branches of government. Nonetheless, that gives you a little flavor of the debate behind the scenes that is going on. And now let's get to what the court ultimately held and how it broke down in terms of the members of the court. When the Supreme Court issued its decision, it concluded by a vote of 5-3 that Harry Bridges prevailed. They started by recognizing that any of the statements of Harry Bridges that were favorable towards leftist policies were simply words uttered that he had free speech rights to utter, and they did not teach or advocate overthrow of the government, nor show an affiliation to the Communist Party. From there, they concluded that the unsworn evidence of O'Neill used to justify the deportation of Harry Bridges failed evidentiary and due process standards, and so ultimately could not amount to a fair hearing to justify his banishment. The majority took what it deemed a, quote, meticulous, end quote, approach to the nature of hearsay when they looked at O'Neill's testimony. They concluded that Judge Sears had made the mistake of admitting the testimony not as impeachment, but instead as substantive evidence, and that was an error. They held, quote, the rules are designed to protect the interests of the alien and to afford him due process of law, end quote. In other words, because O'Neill's alleged statements to government investigators, which had never been memorialized in an affidavit, were hearsay, at most they could be admitted to impeach, but they could not be admitted as substantive evidence, and they were thus wrongly taken ultimately as substantive evidence. In this sense, it's a strict construct of the evidence rules. When the concepts of evidence were framed in light of the overall circumstances of the case, the majority concluded that Judge Sears and the Attorney General had simply gone too far. The majority said, quote, here the liberty of an individual is at stake. Highly incriminating statements are used against him, statements which were unsworn and which under the governing regulations are inadmissible. Though deportation is not technically a criminal proceeding, it visits a great hardship on the individual and deprives him of the right to stay and live and work in this land of freedom. That deportation is a penalty at times, a most serious one cannot be doubted. Meticulous care must be exercised lest the procedure by which he is deprived of that liberty not meet the essential standards of fairness. End quote. Justice Murphy's concurrence was powerful, and he read it from the bench. The words pointed at the government and aspirational for the system of justice to do better. He said, quote, the record in this case will stand forever as a monument to man's intolerance of man. Seldom, if ever, in the history of this nation has there been such a concentrated and relentless crusade to deport an individual because he dared to exercise the freedom that belongs to him as a human being and that is guaranteed to him by the Constitution. End quote. He further went on saying, quote, it is not surprising that the background and intensity of this effort to deport one individual should result in a singular lack of due process of law. When immutable freedoms guaranteed by the Bill of Rights have been so openly and conceitedly ignored, the full wrath of constitutional condemnation descends upon the action taken by the government. And only by expressing that wrath can we give form and substance to the great, the indispensable democratic freedoms to which this nation is dedicated. End quote. Interestingly, Justice Frankfurter was in the dissent, and you heard earlier his comments as the justices discussed the case which affected his ultimate viewpoint in terms of how to manage it, notwithstanding his own perception of deep problems with the case. Now, as I told you in the beginning of this program, the campaign lasted over 20 years period, and we are in 1945, not yet at the 20-year mark. Notwithstanding that wrath of constitutional condemnation in 1945, the government created further cases against Harry Bridges to further try to deport him and imprison him first, so as to remove him from the country. Of course, this program is titled Part 1 because there is a Part 2, which you can watch in due course. And if you cannot wait, well, you can read the book and see the full exciting history of all the courtroom drama and all the cases. But nonetheless, I will set the stage for the future cases and let you know what happened after this incredible victory Harry Bridges had at the Supreme Court. Finally having prevailed, Harry Bridges went to swear in as a citizen. One of the questions that he had to answer when he swore his oath to become a citizen was that he had never belonged to the Communist Party. That was a standard form question for citizenship. He swore in and said, quote, "I have not, I do not," end quote. That is, he swore that he had not ever been and was not currently in the Communist Party. Having just won before the Supreme Court, as well as the very first trial on this exact question, he no doubt felt secure that he was now able to become a citizen and move on with his life. But that act of swearing under penalty of perjury would lead to subsequent criminal cases charging him with perjury in making those statements, the subject of my book and the next part of this series, where the government doubled down and sought to imprison him for that act of swearing in. Now let's look at the legal issues as we wrap up the program in our assessment of what is a weaponized legal system and when does prosecution cross the line to persecution. Ultimately, the Supreme Court concluded this was indeed a crusade that lacked the hallmarks of due process, rendering this case an actual case where the U.S. Supreme Court has concluded that there was indeed persecution by prosecution, and where indeed the legal system had been weaponized in an improper way. So let's unpackage what were the hallmarks of the errors that led to that conclusion, because this is very important for us in modern discourse to see how courts have adjudicated these questions before, so that we may know if, when we were talking about cases today, whether they are indeed persecutions by prosecution through an improper weaponized legal system, or whether they fall on the line of good faith prosecutions. These questions, of course, come up in all manner of modern contexts, not just prosecutions against former political people like the president, but also in contentious social policy areas where we have other politicians being prosecuted, or corporate executives being prosecuted for shareholder fraud and the like. The first point that framed heavily the ultimate conclusion of an improper legal proceeding being used to really achieve political ends was the fact that it ultimately began with Congressional Bill of Attainders and a desire to use the law largely to focus on one person. Ultimately, the fact that the laws enacted was not an unlawful bill of attainder meant that the law itself was perfectly legal, but that framing of how the law came into effect ultimately affected the perspective of the judges when they looked at the four corners of a given record to understand what happened to the person in the legal case. We saw that in particular with the Ninth Circuit dissent that specifically said, the trial that unfolded was ultimately no different to a bill of attainder having simply been issued by the legislative branch. And we saw it echoed in the majority and concurrence in the United States Supreme Court when they concluded that the trial lacked the basic hallmarks of due process and amounted to a crusade. The second point becomes our technical legal discussion of hearsay evidence as it applies in administrative proceedings under the regulations at that time, which itself is not a perfect analog to today, but which is important to unpackage. Among dozens of witnesses and over 7,000 pages of transcripts, the case ultimately turned on one witness, who on the witness stand under penalty of perjury, as a government witness claimed that he never saw Harry Bridges pasting stickers into a Communist Party book. And then witnesses were put on the stand to try to impeach that statement and show that he indeed had once said the opposite. Under the regulations at the time, that became an improper use of hearsay evidence, which was bootstrapped into not just impeachment, but substantive evidence from those underlying impeachment witnesses to prove the government's case. That is, it was a use of evidence that went a step too far. The third hallmark coming out of this case in terms of a persecution by prosecution campaign is the fact that the case began in the executive courts, the immigration courts controlled by the executive, not the federal district courts or state courts. This became an important framing principle for the subsequent judges, as we saw throughout this program, and it cuts both ways. On the one hand, there are issues of deference to the executive, which allowed some of the judges, such as the district court judge and the majority of the Ninth Circuit, and the dissents on the U.S. Supreme Court, to conclude that regardless of how they felt about the ultimate outcome they needed, to give a level of deference to the fact finders in the first instance making credibility calls. On the other hand, as we saw echoed in the opinions of the judges and justices who concluded the opposite, we see that they were unwilling to give deference to back the facts being developed through improper means, and the fact that this was occurring in an environment where the Attorney General was able to exercise the level of control he had simply became a confounding factor for Article III judges when looking at the case. These ultimately frame, then, how the judicial branch used concepts of deference and standards of review to ultimately unpackage what was happening and decide whether it was appropriate or not. Many of these factors, of course, do not apply in a lot of current cases, which start in state or federal courts and work their way up through those judicial branches. But many of them also, we can see, do apply by analogy. And one of the key principles that distills from this case, in terms of seeing how appellate and higher court judges look at trials and evidence that happen in cases that are brought within the courts, where such cases have huge and larger political and social overlays to them, is that the judges take a much more aggressive view of the facts and the evidence and the evidentiary standards, and are less likely to engage in acts of deference than they may in your prototypical case that does not touch such large issues. For Harry Bridges, the fear of communism in that era was the major issue of the time that framed everything. That is one of the lasting lessons that comes from the United States Supreme Court in this instance, in terms of assessing when a very contentious case has crossed the line from appropriate fair prosecution to what the Supreme Court called a crusade. It turned on what the majority of the Supreme Court ruled in such a contentious case with larger political and social dimensions. It demanded that the most meticulous care be exercised when so much was on the line in such a legal controversy, and it demanded that as an elemental part of due process. In any given case, what is sufficient meticulous care in the use of evidence or other trial issues is the fault line for higher court judges to ultimately assess and decide. Finally, let's circle back to the lawyers and some of the lessons in these cases, as there are important lessons for all of us to take in terms of legal advocacy and respect for lawyers and lawyering in hard-fought cases. We saw how the lawyers became a focus of the FBI in terms of discussing what files may be in the lawyer's possession that could be advantageous for the government to have. And we also saw the FBI's letter that, in the event of a national emergency, these lawyers who were litigating these cases should be detained. These, of course, are deeply concerning aspects of that era's hysteria over communism, but we should not forget that we as lawyers can find ourselves facing very difficult odds. And that can make for very contentious cases in terms of the advocacy. One good example to discuss is on the side of how we need to maintain balance as lawyers when litigating these cases, even when we feel what is going on is deeply inappropriate. For example, Harry Bridges' lawyers ultimately won because they stuck to the facts and law, but along the way we can focus on some of the arguments they made that were discarded as being improper, probably a function of the fact that they were so frustrated and aggrieved that they felt the need to cast stones back at the government lawyers. This tit-for-tat created the situation that we, of course, today know quite well, in terms of our advocacy and risk of alienating judges with them being upset at everyone and risking our credibility by overreaching. Specifically, in the Ninth Circuit, one of the arguments made by Harry Bridges' lawyers was that government officials themselves were involved in perjury. That did not go over well in the Ninth Circuit, which held, quote, "this aspersion upon the integrity of the government attorneys as wholly gratuitous and without foundation in fact," end quote. It is a good reminder of the importance for us as lawyers in terms of maintaining the right level of balance as we zealously advocate for our clients. That same charge of perjury against the government was not repeated in the Supreme Court, and that was a critical aspect of the subsequent advocacy engaged in by the lawyers to stay focused and not risk damaging their credibility by overreaching in their arguments. That brings us to an end today, well, of part one at least, as we explore persecution by prosecution and legal crusades within the courts. Thank you for watching, and stay tuned for future programs, and watch all our myriad programs of fun, interesting education content from New Media Legal Publishing.